So thank you for everybody coming to the privacy talks. I'm quite honored to be with Matthias from Germany. He's an expert and he has a very practitioner in the space of the data protections. I'm quite honored, Dr. Matthias, being with you in these times and talked and interviewed this moment. Thank you for coming this time.
Thanks for having me.
Thank you.
Thanks.
So let me start to speak about his profile. Dr. Matthias is a certified lawyer and a senior legal counsel at Deutsche Bank AG since 1999. Prior to joining Deutsche Bank, he worked as a lawyer at the law firm in Stuttgart, Germany. He has been practicing data protection law for many years and was particularly involved in the implementation of the GDPR within Deutsche Bank AG. He advises internal clients globally regarding data protection issues, as well as complex international outsourcing agreements involving data privacy related matters and regulations. He's a graduate of the University of where he obtained his Doctor of Law degree. Moreover, he is a member of the International Association of Privacy Professionals, IAPP, since January 2018, a Certified Information Privacy Professional Europe, CIPPE. Since January 2020, he is also a member of the European Advisory Board of the IAPP. So again, it's very honored to be with you, Matthias, to talk with this interview.
And with me, it's an honor.
Thank you.
Talking to you today and sharing some insights and some background on the European privacy regime.
Yeah, honored. So anyway, let's start with the first topics. I'm very curious of your profile, why you start to work at the privacy field. Since we were in the same panel at the one conference, privacy conference, which was very great to meet with you. And I was being inspired. You are very great expertise. So why did you start to work on the data privacy field?
Well, thanks for the kind introduction. Yes, before joining the data privacy department at Deutsche Bank, I was covering many legal areas, starting from capital investment law, credit law, and all this such sort of things. And interestingly, when acting as a legal risk manager in Frankfurt and London, I had to deal with some data privacy related topics, and that drew my attention and aroused my curiosity. And at the same point of time, and by coincidence, there was a vacancy in the data protection department in Frankfurt. And I took this unique opportunity to join the team. By the way, a decision I've never regretted. In the sake of the birth of the GDPR, you have just mentioned it, in 2018, data protection has been considered as an evolving and a growth area, as it is today. And it's really worth to know that data protection law has become a standalone legal area. Data protection is not an appendage to IT law or IP law anymore, as it was until 2018. And this is a fairly similar development as blockchain law, which has also become a very independent field of law. In view of these developments, many law firms ramped up their teams with a clear focus on data protection. And overall, this was, for me, the encouraging trigger to exclusively focus on data protection law. And it goes without saying that being a privacy professional definitely strengthens your own job profile internally as well as externally. Acting as an in-house lawyer, I have to say that data protection is very often an issue when it comes to assessing new business cases. And data protection experts are deemed as key stakeholders from the outset, and business is strongly demanding their advice and expertise. So in a nutshell, to answer your question, Kuwait, data protection has stepped out from its niche. It has become an emancipated field of law of utmost importance. And this was for me the motivation to heavily focus on data protection. And it's something I will do post-retirement for sure.
Awesome. Yeah, I was leading some of your publishing before, then there was also the very informative, then I was very inspired since I just watching some information regarding in Europe from Japan. It's very hard for the Japanese people to understand of how does it works in Europe, then also they try to apply to the baselines of the Europe. So the next question about the transitions. I think it was in a tsunami of the data privacy space right now, especially the one legal scheme, the SREM 1 and SREM 2. These almost 5 or 6 years. So that was a very big impact for all the industries, especially for the banking sectors, I assumed. So what is like the impact of this SREM 1 and SREM 2, especially on the banking sectors so far?
It's a very good question. And SREMs 1 and 2 not only impacts banking, the banking industry, but all industrial sectors which export and which process personal data and envisage to export personal data to a third country. And just to put this question in a broader context, I guess most of you may be familiar with this stuff, but it's sometimes very beneficial to see the historical development of this. The Schrems case was challenged, or the Schrems case challenged the Irish Data Protection Commissioner's refusal to investigate a complaint submitted by Max Schrems. Max Schrems is an Austrian data protection activist, and this guy requested the Irish Data Protection Authority to suspend data transfers from Facebook Ireland to Facebook United States. And that was due to Mr. Schrems' concern that the Snowden revelations suggested his personal data could be accessed by US intelligence services and his privacy rights would be at risk. And at that point of time, Facebook relied on the safe harbor framework, which had been put in place between the European Union and the United States. And it was as a legal, should be considered as a legal basis for personal data transfers under the EU Data Protection Directive. The Irish High Court referred the case to the European Court of Justice. And in 2015, the European Court of Justice ruled that the European Commission's adequacy determination for the safe harbor framework was invalid, and which led to the creation of the privacy shield framework between European Union and the United States. In a separate case, often referred to as Schrems 2, the European Court of Justice invalidated the European Commission's adequacy determination for the privacy shield. And that decision was launched in July 2020. What is the impact on the banking sector on this regard? So Schrems 2 is clearly a landmark decision and entire game changer for international data transfers for all data exporting companies in the EU. So in a nutshell, Privacy Shield is dead. It remains to be seen whether the Privacy Shield will be reloaded or reactivated. Discussions are going on. Nobody knows what's happening by end of this year, but for the time being, the Privacy Shield is not a legitimate transfer mechanism anymore. The good thing is companies which export personal data to any third country without an adequacy decision may rely upon the EU Standard Contractor Clauses. They still remain valid and can be used as a legitimate data transfer mechanism. Here's the flip side on this. According to the new requirements of Schrems 2, data exporters and importers must closely cooperate, aiming to assess the individual data transfer on a case-by-case basis, and to safeguard personal data if the data may be exposed to mass surveillance activities or data exposure, disclosure requests carried out by third country intelligence services or authorities. And that risk assessment is called transfer impact assessment. So EU data exporting companies or companies which export personal data to third country importers or service providers have to conduct such transfer impact assessment, namely upfront to transmitting personal data to data importers located in a third country. And this necessitates a case-by-case consideration, determination, and documentation regarding the permissibility of such data transfer. And at that point of time, the guidance of the European Data Protection Board issued in June 2021 comes into play. It's a great tool which helps data exporters to conduct a case-by-case assessment in relation to the concerned data transfer scenario. The overall impact on companies is that they have to build up their own governance models, like Deutsche Bank does, and to implement new processes and procedures from scratch in order to stand up to scrutiny of the competent data protection authorities when carrying out transfer impact assessments.
Thank you. Yeah, it's moving so fast, and it's moving a very complexities, especially for the new SCC, which is also the concerns of some of the global companies who try to take this choice of these new tools. I think the new SCC will be in the requirements, the deadlines of the in some months later. So what is the features of the new EU SCC in this moment?
I think the most pressing issue is to establish a new standard contractor clause when it comes to transmitting personal data from the EU to third country service providers. Just to put it in a broader context, the Commission, the European Commission, issued the new standard contractor clauses in June last year. It's worth to know that the Commission have baked in the Schrems 2 requirements alongside the key terms for data protection agreements according to Article 28 of the GDPR. With that, it's fair to say that the new model clauses, the European Standard Contractor Clauses, are, I would say, catch-it-all templates and must be put in place for any cross-border data transfers to third country data importers. So what are the quirks and features? The new standard contractor clause have been split up into 4 modules, which reflect 4 relevant data transfer scenarios: controller to processor, controller to controller, processor to controller, and processor to processor. So we have got 4 modules, and all of them are commingled in one contractual template. This is not easy to digest and to understand. So it's much better to split this single template up into 4 separate contractual templates, which reflect 4 data transfer scenarios. All of them are available. So the first thing we have to consider is what kind of data transfer is still relevant. In most cases, we have a controller to processor scenario, and then you can pick out the relevant template, which enshrines all the related requirements of Schrems 2 and the Article 28 GDPR terms. The obligations laid out in the new standard contractor clauses require data exporters, and this is important to note, to permanently monitor surveillance laws and practices in the foreign country where the personal data is transferred to. And this will enable companies to conduct the so-called transfer impact assessment thoroughly. The first thing is you have to assess the legal and regulatory environment, the practices, how the law is being applied in practice. And the next step is to assess this individual data transfer to that third country data importer. The transfer impact assessment entails an overload of assessment and documentation activities. Any failure to do so is heavily sanctioned. It goes without saying that you have to do it anyhow, and whatever you do and whatever you assess, the outcome must be documented properly in order to prove evidence that you have done your job in the right way. Whenever data protection authorities want to see what kind of assessment you have taken, you should definitely be ready to present the outcome. By the way, the obligation resides with data exporters based in Europe. I would like to stress based in Europe. And it's worth to know that data importers in third countries which envisage to subdelegate services or to onward transfer personal data to any other subsidiaries or subcontractors are not required to perform a data impact assessment. Yeah, it's only related to data exporters which are based in the European Union.
Thank you. Yeah, it's very, I feel it's a very complex. Even some company has been adopted the former SCC, but the new SCCs are coming right now. It's very hard for them to adapt not just the contractual base, but also the organizational or technical measures has to be requirements for the transfer impact assessment. That is a very important supplementary measures. So my next question is about, in addition to the SCC, some of the companies that try to choose the BCL, binding corporate rules. There's the few of the Japanese companies that try to do that as well. But the thing is, the BCL is also the requirements of the TIA transfer impact assessment. So how does it actually works from the European perspective?
It's a very good question, and it's a tricky one as well, because there are many companies who have very painfully established their own binding corporate rules. And as you may know, the binding corporate rules need to be approved by the competent data protection authority. And whenever we are dealing with large players, they point to their own binding corporate rules. And I've had some very interesting discussions with them because they think we have binding corporate rules in place and that's it, and you don't need to do anything more. So the question is, and you just mentioned it, whether the transfer impact assessment is applicable to binding corporate rules. It's clearly the position of the European Data Protection Board that Schrems 2 replies to binding corporate rules as well. So that means that companies that transfer personal data originating from the EU under their own binding corporate rules may need to perform the transfer impact assessment and put in place additional safeguards in the same manner as companies that are relying on standard contractor clauses for their data transfers. And the downside is, and this is absolutely subject to our discussions, that this potentially undermines one of the key reasons why companies opt for binding corporate rules in the first place, namely to create a transcontinental zone within their organization. However, companies which rely upon their binding corporate rules, even if they are approved, they may need to perform a case-by-case risk analysis whenever they want to cross-border data conduct a cross-border data transfer. This is very painful, and this is something I need to tell people or the suppliers every time, but this is how it goes.
I see. Yeah, it's very challenging. The company, even they are get approved, but they have to need additional requirements to prove that the protecting the consumer data. So that is very important notice for the companies to work for these challenging situations. I also very interesting theme about the adequacy decisions, especially in between the Europe and then Japan has the adequacy decree right now. I was reading the guideline of the EDPB, which is also the requirements whether in bilateral data transferring, whether they have the inadequacies baseline in each of them. So when it's come to the what is the consideration, the specific for the data transfers from Europe to Japan based on the adequacies requirements?
Yeah. When I was talking about third country data transfer, I was only referring to countries in third countries without having an adequacy decision in place. So the European Commission has launched a series of adequacy decisions for Canada, by the way, for South Korea very recently, and for Japan as well. I think in 2019, the European Commission determined adequacy, particularly with regards to the APPI, which has been subject to some overhauls over the last years. APPI stands for Act for Protection of Personal Information. And you have a very strong data protection authority in Japan, and all things together gets the European Commission to release the adequacy or to determine adequacy with regards to Japan. And interestingly, data exporters based in Japan must adhere to similar rules when transferring personal data of EU's individuals outside Japan. Yeah, it's worth to know that there's a treaty between the EU and Japan in place, which came into effect in February 2019. So very recently, and which stipulates additional guarantees in order to safeguard EU personal data, which is being transferred to Japan. So in a nutshell, I would say if a European-based company wants to transfer EU personal data from the EU to Japan, you don't need to put in place a new model clause because Japan has obtained adequacy, and any onward transfers from Japan to other countries outside Japan follow their own rules. This should be in line with the APPI and some treaties. So that's not a big thing to transmit personal data from the EU to Japan.
Yeah, I think it's very important to trusted the niche of the safeguard level isn't in the same, especially the country level. That's a very big advantage for the enterprises, not just to take any big costs and the burdens to prove that they are in a safeguard. So that's a very great advantage in between in Europe and in Japan. So we have to continuously working on the protections issues against of the intrusion of the some of the consumer rights. It's very important issues right this moment.
Yeah, and Japan is a safe country, and the upside for European companies is, first, there's no need to put in place model clauses. Second, and this is the most important thing, there's no need to drive a transfer impact assessment. So it goes similarly when transferring data from Germany to France. So you only have to you have to incorporate a data protection agreement or data protection schedule, but you don't have to care about any requirements related to transfer to international or cross-border data transfers.
Awesome. So the next topic it's a different angle. That's I've been working at the blockchain space for almost 3 and 4 years so far. On the last session, we came on together. There was in the topics of the blockchain and GDPR that is very important. We try to portion in such as the Web3. It's kind of the new trend that we are trying to chase in how the technology migrated into the real scene, and especially the data space. So the next question about the GDPR and the blockchain. So what are the tensions in between data protection and blockchain technology in this moment?
Yeah, there are tensions between the GDPR and blockchain by nature. And just to name some of the war zones, I think that those are the most important ones. Though the enforcement of data subject rights is very tedious and very cumbersome in practice. You can start looking at particular data subject rights, starting with the right to access data written onto the blockchain. So in a public blockchain, I would like to stress public. In the public blockchain environment, it's not an easy thing to identify a controller. Because there are many players there. We have wallets, we have oracles, we have users, we have developers, and who is doing what? It's not clear, and I will get back to this point in a little while. Not everybody who is operating in a blockchain context can be deemed as a controller. So, but imagine you have just nailed somebody down acting as a controller. It is factually very, very tedious, and this controller is factually unable to access data submitted to the blockchain. This is because the data is typically encrypted or hashed, and it's nearly impossible to determine whether the related data is personal or not, and relates to the individual, the data subject, who is raising the access request. Another interesting aspect is the right to modify or delete data. And this is a common topic, and everybody who is elaborating on the GDPR on the one hand and the blockchain technology on the other hand, pinpoints to this legal topic here. The problem is, at first glance, it is impossible to alter or to delete data from the blockchain. Once the data has been submitted to the blockchain, it remains there due to the immutability of information submitted to the ledger. This is one of the key features of the blockchain environment, that all data, all information stored on the blockchain is there, remains there, but there are we can talk about some workarounds, how to deal with data access or data deletion requests, right to be forgotten in a little while. And I can show you there are some workarounds, some tricks, how to comply with such data subject requests. Another topic I just mentioned, it is the GDPR has predefined certain roles. We have only 3 roles: controller, we have a joint controller, and a processor. That does actually not match the various tasks associated to blockchain players. Just mentioned oracles, users, wallets, developers. And in private blockchain, we have governance bodies as well. So you need to stick to the details and to determine case by case what is this participant in the blockchain environment actually doing, and can his operation be associated to either a controller role or a processor role under the regime of the GDPR. And this is what I try to flesh out a little bit in more greater detail in the handbook I've written, or I have co-authored this handbook of blockchain law, and you may find there a little bit more context. Who is doing what, and who should be deemed as a controller or a processor. And most importantly, there may be some players who only may be associated to the blockchain infrastructure without taking over a role as a processor or controller. And one of the key features of blockchain is that all information written on the ledger is immutable. I just mentioned it. And this feature clashes with the principles of data minimization and purpose limitation. The latter one is the backbone of all advanced data privacy regimes around the globe. So what does it mean in a blockchain context? The blockchain continuously processes personal data by storing it. And please note that whenever data is being written on the blockchain, it is being stored there, and storing is one subset of a processing activity. So storing equals with data processing. And the issue becomes critical when personal data is not needed anymore. Yeah. So what happens once a data processing operation has been completed involving personal data? Then you have to think about how deal with this piece, how we can deal with this issue whenever legacy data is not needed anymore, because this is an infringement of the violation of the purpose limitation and the data minimization principle. This is something which you have to thoroughly assess when, if you are a company and you want to leverage a blockchain solution for your business case. You have to think about it. What should be done or must be done with the personal data, even though the personal data is being hashed or encrypted. That doesn't matter. Hashing and encryption does not alter and does not convert personal data to non-personal data, but you have to think about it, how to deal with legacy data, the data which is not needed anymore.
Yeah, I totally agree. Then it's a question. The decentralized data has the technically issues at this moment that is not easy to overcome than just choosing any other solutions. It's essentially decentralized mindset has a conflict in between the centralized rule. So that is a lot of the challenges for the blockchain people, but as well as the regulatory side to solve the issues for the new technical developments. So in terms of the clears of these issues in this moment, so what is the solution? What is the technical choice to mitigate the data protection risk in this technical thing?
Yeah, I think there are a couple of considerations. Maybe you have to split up the question into the technical features. So you may leverage smart contracts. So smart contract algorithm may determine from the outset what volume of data, what set of data is being stored in order to ensure the data minimization principle. And the smart contract may also help you in order to execute requests of individuals who envisage to access their data or get them deleted. Give you one example. Maybe talk about access requests. The access request raised by an individual, a data subject, must be considered as an event outside the blockchain. And this request may be processed through an oracle, and the oracle transmits the particular request to the blockchain network, and particularly to the smart contract algorithm, which executes the request by decrypting the data and providing the relevant information to the concerned data subject. This is something which is fairly new, which has not developed, but it's from the theoretical point of view an feature, a workaround, which may help companies to comply with data subject right requests. Another thing I just touched upon this is when I was talking about data deletion, is a hashing out technique. It's quite complicated, but in a nutshell, it boils down to dealing with legacy data. You can put the legacy data, the data which is not needed anymore, or because the underlying transaction or the data processing activity has been completed. You can put them out of the blockchain and store the data, the legacy data or the reference data, however you call it, off-chain, outside the blockchain world, be it in a PowerPoint and Word or an Excel sheet. But it's important to put a hash value as a placeholder onto the chain, because I just told you the data stored on the blockchain is not immutable. You cannot change it. Yeah, it's not changeable, but you can replace the reference data by a hash value onto the blockchain. The next step you have to do is delete the off-chain legacy data or the reference data, and if doing this, the hash value will become a random string without any meaning. Why? It is certainly not possible to reverse engineer the reference data from the hash. So the deleting the off-chain reference data from the external database has a huge impact on the hash value itself, which converts into non-personal data. And this is the only way to meet deletion requests in order to be compliant with the GDPR. I know this sounds very complicated, and it is definitely complicated, but it is doable. It is a workaround, and it showcases that the statement that the blockchain technology is not in sync with data privacy principles is not true, because you can comply with data privacy, with the GDPR in particular, but you have to do a little bit more. You have to define and to elaborate on workarounds. You can leverage smart contract algorithm, and most importantly, you can implement hashing out techniques. And this may help companies to if they start thinking about leveraging blockchain solutions for their business cases, they can, following the privacy by design principle, implement hashing out techniques in order to be compliant whenever personal data is submitted to the blockchain, even though the personal data is being hashed there. And in the case data subjects want to delete their data, raising the right for erasure, then it is doable to comply with these requests accordingly.
Awesome. Yeah, it's a very challenging. A lot of things we have to be considered in advance to take the choice of the blockchain technology. It was very easy at the first, and technical evolves in the market, but right now it's in a conflict in between the real world, based on the data protection regulations, as well as the some of the new regulation, such as e-privacy, such as the DSA, DMA. A lot of the regulation is coming into the European space. That could be the conflicts in between new technical scene. what we have to consider to make a flourish of the new technical returns through of that. So that was a very great the insight from your experience, Matthias. That was a very we inspired from your idea. So lastly, I'd like to ask you about the message to the listeners who wants to know about the European perspective. What is the requirements and the data protection scene in this year?
For this year, the forecast. What is?
Of course, so for this year or for the next decades, or we are trying to change the mindset, not just using a personal data. We have to take in the balances, the protections you say. So how we can do that?
Yeah, I think it is very, very important to take data protection very seriously, not only given to the very heavy sanction regime, but I think if you take it seriously and you use privacy by design principles and you even in a blockchain context, if you implement pseudonymization or encryption techniques from the outset, just to try to reduce the impact on data privacy rights significantly, then I think you are on the safe side and you will have a competitive advantage against your peers. I think no company can afford to be incompliant and to be sloppy. To give you one example, it occurs to me, back in maybe 2016, 15, to be honest, and I think this is a common view, no company cared about model clauses. The only thing they have to do is to take this scrap of paper, put it into the contract, and that's it. So nobody reviewed the old model clauses, nobody took care of it. And this is why Max Schrems figured out, and he was very persuasive, and he made European institutions aware of this deficiency, and now we have new model clauses and new requirements, and we have to follow the rules. That's it, yes, and we have to think which scenario, which data transfer scenario is relevant, and what we have to do more. We have to conduct transfer impact assessment to have a clear view on the risk exposure of data if you want to transmit them to a third country service provider. And this is what I told you. This is an extreme game changer. Yeah? You have to take care, and this is companies are urged to take care of personal data, not only if the data is processed in their space in Europe, but most importantly, if they want to transmit data cross-border to third countries, then the world looks differently, and they have to do a little bit more opposed to what they have done in the past. Yeah. So my advice is take data privacy very seriously. The sanctions are very similar to antitrust sanctions, and if you fail to do so, you are definitely on the hook. Yeah, you have to weather the storms, and data privacy is of utmost importance. When I started working as a privacy lawyer, people I would not say arrogant, but we have been the last stakeholders in the pipe, and now we are the most important ones. Yeah, our advice is the first one they want to see, and we have been involved in so many business cases and projects from the very beginning. The business is and not only in Deutsche, but also in other companies as well, they are very, very alert, and they are very conscious that data privacy is a topic they should really look at in greater detail. And they are well advised to request data protection related legal advice, be it internally or outside their company. That doesn't matter. But this is definitely a good investment for the businesses.
Yeah, brilliant. Then it was very important, as you mentioned, that the company has to, in considerations before they starting a data business, the privacy first. That's gonna be the game changing right now. Then they have to invest it in this scene. Then, and also we have to cooperate together to make it a more protective the environments for the customers, for the users can be safe, can be protected. That is our mission, the commitment to prove that's in the futures of the data society. So thank you for Matthias then coming today and having a great talks this time. So I'm very appreciated.
Pleasure
with
for
your
me.
great
Thanks.
insights.
Thank you so much. It was
Thank
great
you.
speaking to you and sharing my view.
Awesome. Thank you.
Great. Thanks a lot.